So now Booking.com, sort of the main event. I don't really think this was the big case that we all thought it was going to be, but you know, it's significant for a number of reasons. A, it was the first oral argument that the Supreme Court heard while they were sort of working from home like all of us were. And sadly, it ends up being Justice Ginsburg's last majority opinion. So I'm sure everyone knows, but in case you don't, if you don't practice in this area regularly, this is a case that determined whether a generic term plus a top-level domain could function as a trademark. And spoiler alert, the court said it could. So Justice Ginsburg wrote this decision. It was an 8-1 decision. Justice Breyer dissenting. We'll talk about Justice Breyer's dissent because it is an interesting dissent and interesting points and concerns he makes. But the majority rejects the bright line rule that the USPTO was making. And they dismissed the USPTO's per se rule that a generic term can never function as a trademark. Since it was clear to the court that consumers perceive the Booking.com mark to function as a trademark, it therefore held it to be eligible for registration. There's many great quotes in the opinion, but I think this was my favorite one. And Ginsburg writes, if Booking.com were generic, we might expect consumers to understand Travelocity, another such service, to be a Booking.com. We might similarly expect that a consumer searching for a trusted source of online hotel reservation services could ask a frequent traveler to name her favorite Booking.com provider. I mean, it's just so preposterous. No one would do that. I would say to Chip, hey, who do you use to make your travel arrangements online? Or what's your favorite online travel reservation site? Or what site do you use to book your travel arrangements online? I would never say, what's your favorite Booking.com provider? It's just preposterous. And I think the majority understood that. I think also at the heart of the majority's opinion and their concerns to rule in favor of the USPTO was that they were arguing for this bright line rule. And Booking.com's legal team was very, very shrewd in their brief. They included many, many, many seemingly generic issued registrations. This is just a small example of them taken directly from their brief, from a presentation that one of their attorneys gave that I included in our presentation. The court was very concerned about having to cancel a number of issued registrations. But you can see here, just in these 10 or 12 registrations, that there's a huge inconsistency here. And again, for those of us who practice in this area often, we know that the USPTO is nothing but inconsistent in how applications are examined. Justice Breyer's dissent is well reasoned. He bases his dissent on anti-competitive concerns. And he was the lone dissenter. He was very concerned about the ability of a top-level domain to add any distinctive quality to an otherwise generic term. I think perhaps, and I don't want to speak for him, but I think perhaps where he wasn't understanding, I think what the majority seemed to understand well, is that much like your address, where you are the only person, and I'm going to use person to mean you and your family, you're the only person that can live at 123 Main Street, right? There's not 5 people that live at 123 Main Street, and I use 123 Main Street as a placeholder like I would for Acme as a brand. Now, there could be many 123 Main Streets in different cities, but in your city, you're the only person that lives at your street address. And I think Booking.com did a good job of arguing in the oral arguments that that top level domain, right? Your URL address is unique. Only one company can hold it at any one time. So, booking.com is owned by booking.com, BV, and unless and until they transfer it, they're the only entity that owns it. And so I think Justice Breyer just really didn't completely get that, maybe. I'm not sure from his questions. It didn't seem during oral arguments that he understood that. He was very concerned about the ability of a top-level domain to add a distinctive quality to an otherwise generic term. He also was really stuck on the probative value of the survey evidence.